Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal lawsuits to enforce the USCIS Form I-864 Affidavit of Support. In most cases, a claim under the I-864 is going to result in a settlement agreement. That's a great thing for both parties. It means that the time and expense of a federal lawsuit is avoided. In a lot of cases, that settlement agreement is going to involve some structured payment over a period of time. So you might have an initial payment representing perhaps 30% of the damages that are owed under the Affidavit of Support, and then periodic payments are made by the defendant, usually on a monthly basis. A question that my clients have very often is what happens if the defendant violates the term of the settlement agreement. So if you have a situation where the defendant's going to be paying, I'm just making this up, but $2,000 a month to make progress on those damages that are owed under the affidavit, what happens if the defendant simply stops paying? As a practical matter, I will say that's actually pretty rare. Usually after a defendant has acknowledged liability under the Affidavit of Support and has agreed to make a certain amount of payments, typically they honor that agreement. And we actually see relatively rarely that this results in a dispute. So usually once you have your settlement agreement, it's pretty likely that you're going to be able to rely on the defendant to simply perform the obligation, make the payments due under the agreement, but not always. And so every settlement agreement is going to have some provisions for what happens if the defendant doesn't live up to their agreement. The settlement agreement itself is a binding contract and it can be enforced in court. Typically, a couple of the types of provisions that we would include in a settlement agreement to make enforcement easier if we have to. There will be a default provision. So it explains that if the defendant has failed to make a payment under the settlement agreement, typically after a 3-day or so period, the defendant is deemed in default. We will also include something called an acceleration clause, which means that, let's say there are, I'm just making this up again, but 2 years of payments that are due under the contract. If the defendant fails to make a payment and then doesn't get back into compliance with the payment in a big hurry, usually 3 days or so, then all of those future payments that are due under the agreement are now accelerated. So they are now due immediately by the defendant. And then there's typically also a damages provision associated with a percentage of what's due. So for example, if we had 2 years of payments, those would become due immediately, and then there would be an 8% penalty assessed against the sponsor. The plaintiff can then go to court and enforce the terms of that agreement. And because the I-864 contract includes an attorney fee provision, the plaintiff, meaning the green card holder, is entitled to recover the costs and attorney fees associated with enforcing a settlement agreement. So those are all pretty severe situations for the defendant to deal with, and they are highly incentivized to avoid that penalty associated with defaulting on the settlement agreement. They want to avoid the expense of having a judgment rendered against them. And if a judgment is rendered, so if they violate the terms of the settlement contract and we have to take them to court and enforce the contract against them, that's going to result in a judgment that can be collected against the sponsor involuntarily. So you can use all of the standard collection tools. Squid Game's ringtone. You can use all of the standard collection remedies, including wage garnishment, bank account garnishment, and property foreclosure to enforce that settlement agreement. Typically, that's not what the defendant wants, and so they are going to remain compliant with the contract. At least for clients working with my firm, after the settlement agreement is reached, and let's say we have, that 2-year, 24-month period where the settlement agreement is being paid down, the law firm remains involved. So if there's a problem with payments under the settlement agreement, my client can come back to me and we can talk about the appropriate way to get the sponsor into compliance with the terms of the settlement agreement. So it's not like the law firm disappears after the settlement agreement is reached. We remain involved all the way until the settlement agreement is fully paid down. If you have questions about settlement agreements under the I-864 or enforcement generally, feel free to drop into the comments. If you would like an individualized case assessment via a Zoom consultation, we do that all across the United States. Feel free to contact us. Hope that's helpful.